Hey everybody, welcome back. In this video, we're going to talk about due process and the rights of the accused. Let's get it. So if you want to know about the rights of the accused, the 4th through the 8th Amendments is where you would look. In this video, we're going to concentrate on the 4th, 5th, and 6th Amendments. The 4th Amendment protects us from unreasonable searches and seizures. So this begs the question, well, what exactly makes a search reasonable or unreasonable? What makes it legal compared with illegal? Well, basically one of three things needs to happen for a search to be considered legal. One is that the police officer has probable cause, good reason to believe that a crime has been committed or is being committed at that moment. Second, they could have a search warrant, which is an authorization from a judge saying this is what can be searched at this time, place, etc. Or third, the person can consent to the search. In any of those three cases, the search is legal and therefore your 4th Amendment rights are not violated. Now, today with technology, this has become a little bit more complicated. For instance, what about your cell phone? Can police look at that without having a search warrant? Could it be the text messages, your call history? What about the metadata that shows them exactly where you've been? So they could say, all right, well, at this time, through triangulation of looking at cell towers and other things like that, or GPS data, they could determine your location at a particular time. Do officers need a warrant in those circumstances? Well, the answer to that question is yes. In a very recent case called U.S. versus Carpenter, the Supreme Court ruled that these types of warrantless searches of cell phone data are unconstitutional. Therefore, police must get a warrant for this, just like they would need to search your house or to search your car. Another controversy over this has been with the USA Patriot Act and now more recently the USA Freedom Act. And what the Patriot Act did very briefly was, among other things, it allowed a much wider range of things to be wiretapped, lots more monitoring and collection of digital metadata by the federal government. The Freedom Act narrowed this a little bit, and where we are currently is that the government can still collect this digital metadata, but they aren't allowed to look at it specifically unless they get a search warrant. So there's kind of a middle ground here. Again, we think about this in the context of our big question is security versus liberty. So the 4th Amendment is there to protect our freedom, protect our liberty, so we won't be subject to these unreasonable searches, but at the same time, other people focus more on the security side, safety side, so where exactly do we fall? That's what these debates are all about. Along with that is the question, well, what happens if police do search you illegally and they do happen to find evidence against you that a crime has been committed? Well, we have something known as the Exclusionary Rule. And the Exclusionary Rule states that illegally obtained evidence cannot be used against you at trial. So the police, again, can't search you illegally. If they do, that evidence will be inadmissible in court. And the reason for this, I think, is pretty clear. If illegally obtained evidence could be used against you in court, well, there wouldn't really be any reason or anything stopping police officers from searching you illegally without consent, a warrant, or probable cause. But since that evidence will be thrown out, now they have to make sure to abide by and protect your 4th Amendment rights. Now, this is controversial because this does make the job for law enforcement a little bit more difficult, and at times it may lead to somebody who is in fact guilty of a crime to get away with it because some of the evidence was found illegally, and so therefore that evidence can't be used against them. One important thing I do want to point out here, though, is that just because some evidence was collected illegally, that doesn't mean the person is automatically let free. They can still be tried with other evidence. Now, the 6th Amendment guarantees you a few things when it comes to your trial. So you have the right to a speedy and public trial by an impartial jury. So this is that idea of a fair and speedy trial. An additional part of the 6th Amendment is also the idea that if you can't afford an attorney, one will be provided for you. So you have that right to have defense, legal counsel while you're on trial. But remember, initially, the 6th Amendment only applied to the federal government, as all the amendments did, before we got to the idea of incorporation. So initially, this was only in federal trials that these rights were guaranteed. Now that has changed because we have Gideon versus Wainwright, one of your required Supreme Court cases. Again, make sure you check out that video to get all the information you need to know all the facts and details about that case. But what that case did was it incorporated the right to an attorney. So if somebody can't afford an attorney in a state case as well, now the state must provide that person with an attorney, expanding that Sixth Amendment right to be applicable to the states. Now we also have what's known as the Miranda warning, and this is the idea that police must inform suspects of their Fifth and Sixth Amendment rights. So the Miranda warning doesn't actually add any new rights to a person, but what it does is it tells police that they must tell people about those Fifth and Sixth Amendment rights. So if you're familiar with any kind of TV or movies, I'm sure you've seen people be read their Miranda rights. So something to the effect of, you have the right to remain silent. That's from the Fifth Amendment's protection against self-incrimination. So the person is warned that anything they say can and will be used against them in a court of law. They also have the right to an attorney, and they are told that if they can't afford one, one will be provided for them by the state, as we just learned in Gideon versus Wainwright. However, there is an exception to the Miranda rights, which is known as the public safety exception. So if at that moment, as that suspect is being detained, there is a situation in which the public safety might be at stake, the police are allowed to ask that suspect a question, and if that person answers the question freely, they may use that answer against them in trial, even though they haven't been told of their Miranda rights yet. In normal situation, if the police don't tell the person about their rights and then they ask them questions, that evidence or the questions, the answers that they give, cannot be used against them in trial. But this is an exception that if at that moment the situation is volatile, if it seems like the safety of the public is at risk, they can ask that person and they don't have to tell them their rights first. So we see again that trying to balance that security versus liberty aspect here. All right, so that's it for this episode. Till next time, this has been a LaMoney production. Alright, thanks again for watching this video. Guys, let me know what you think down in the comments below. Should we be more concerned with protecting the rights of the accused or of maintaining security and safety? Let me know what you guys think. Hit that like button for me. Subscribe if you haven't already. See you guys next time.